Hi everyone, welcome back to Let's Talk Legal with Karimi Chege. My name is Ashley Karimi Chege, an advocate of the High Court of Kenya and your go-to employment expert. This is Season 1, Episode 8 of Employment Law Unlocked, where we'll be talking about overtime. So what are the objectives of today's episode? 1 is to outline what the maximum number of hours of work stipulated by law. 2 is to establish how to calculate overtime. And 3 is to expound on who bears the burden of proof once overtime has been claimed. So let's get straight into the episode. The law provides, under Regulation of Wages General Order 1982, that an employee should not work for more than 52 hours within a duration of 6 days. The law also provides for employees who are working at night, they should not work for more than 60 hours within a duration of 6 days. The law also provides that in a case where an employee is of the age of less than 16 years, they should not work for more than 6 hours a day. Now, I know you have heard me talking about 6 days of the week rather than 7 days of the week. This is because under Section 27 of the Employment Act, the law provides that an employee is entitled to a minimum of 1 rest day in a week. So this could be Saturday or Sunday, and kindly remember that this is the base and not the ceiling. Therefore, nothing stops an employer from giving their employees more than 1 rest day. And that is why you might find that there are people who actually go for rest on both Saturday and Sunday. It is very, very legal. The law also provides, under the Regulation of Wages General Order 1982, that this rest day can be deferred, but only with the mutual consent of the employer and the employee. So both the employer and the employee can agree that the employee can skip going for rest day on 1 week and postpone it to the next week. The law provides that the employee should not have more than 14 days of accrued rest days. And if they do so have such kind of accrued rest days, the same should be utilized the same way as leave days. That is, the employee should be allowed to go home for rest, and the days should be calculated on the full pay of the employee, just like annual leave. However, this does not deduct from the annual leave days of an employee. The law provides, under Section 10 of the Employment Act, that the employer is the party that bears the burden of keeping records of the hours worked by an employee. And that is why you will find in most companies, they either have biometrics or an attendance register that the employees key in their checking in and checking out time for record purposes. The law also provides that upon termination, the employer should keep such records of their employees' check-in and check-out time for up to 5 years after termination or resignation. This is actually an obligation that the law puts on employers. Now let us talk about how is overtime calculated. The Regulation of Wages General Order 1982 provides that overtime is calculated as 1.5 times the normal hourly rate of an employee. This applies where the overtime has accrued during the working days of the employee. That is either Monday to Friday or Monday to Saturday. In the event that the overtime has accrued during the rest day or a public holiday, the law provides that overtime is calculated as double the hourly rate. Now, in a case where an employee is not paid hourly, the law provides that overtime is calculated as 1/225 times the employee's basic monthly salary. Now, there are a couple of things that you also need to know about overtime. The first thing is, overtime is considered as a continuing injury, meaning if you seek to plead overtime pay in court, you have to do so within 12 months from the date of your resignation or termination. Otherwise, your claim for overtime pay will be time barred. Also, another thing to note about overtime is that it is treated as a special damage. What does this mean? It means that you have to stipulate a specific amount that you're claiming as overtime pay. It cannot be made as a general damage. The court needs to know how you calculated that overtime pay figure that you're claiming. It needs to be stipulated. Now, let us talk about the case of H. Young and Company East Africa Limited versus Wycliffe Okoth and Paul Nyakach, 2025. This is a Court of Appeal case that arose from an appeal at the Employment and Labor Relations Court. So for us to be able to understand what happened in the Court of Appeal, I think it is necessary that we first look at the Employment and Labor Relations Court case. So in the Employment and Labor Relations Court case, Wycliffe and Paul, they indicated that they had made this claim against H. Young as representatives of 4 other people. And according to their collective bargaining agreement that they signed in 2013, they were to work for the employer, that is H. Young, from 8 a.m. to 5 p.m. on Monday to Friday, and on Saturday, they were supposed to work for 5 hours. Wycliffe and Paul had therefore sued H. Young and were claiming overtime pay for the period of May 2013 to July 2014, and they were praying for a sum of 942,000 as a cumulative figure for the unpaid overtime pay. According to Wycliffe and Paul, they indicated that they had made numerous requests to H. Young to pay them this overtime pay, but H. Young never acceded to this call. Also, in support of their case, Wycliffe and Paul had produced a computation sheet indicating how they had arrived at the sum of 942,000, which they claimed was a cumulative figure as they were representing 4 other people who were also employees of H. Young. Wycliffe and Paul also produced before the court a staff movement summary report, which indicated their checking in and checking out time in the duration between May 2013 and July 2014, just to prove that they were working more than the 8 hours a day that was stipulated in the collective bargaining agreement. On the other hand, H. Young indicated that they had paid all dues to their employees and that Wycliffe and Paul were not entitled to any reliefs whatsoever. Further, in regards to overtime, H. Young indicated that the same was always indicated in the employee's payslip and settled immediately once salaries had been disbursed every month. In regards to the staff movement summary report, H. Young indicated that the early checking in time and the late checking out time that is indicated in the report was as a result of the common transportation system that they had, where most of their employees were picked up earlier than 8 a.m. and sometimes they were picked from the workplace to their various destinations later than 5 p.m. Now, the ELRC court, after hearing both parties, found that Wycliffe and Paul had made their claim for unpaid overtime and proceeded to award them the sum of 942,000 that they had pleaded for. Now, aggrieved by this decision, H. Young proceeded to file the present appeal before the Court of Appeal, challenging the decision of the Employment and Labor Relations Court. So now the Court of Appeal was found with the task of establishing whether Wycliffe and Paul were entitled to overtime pay. The Court of Appeal noted that the Staff Movement Summary Report indicated that there are days where Wycliffe and Paul definitely checked in earlier than 8 a.m. and checked out later than 5 p.m. This was definitely proved that there were days when Wycliffe and Paul worked more than the 8 hours stipulated in their collective bargaining agreement. The court noted that as per the terms of the collective bargaining agreement, it was agreed that overtime was to be paid at 1.5 times the normal hourly rate for working days and double the hourly rate for rest days and public holidays. The court also noted that H. Young had not provided any evidence to disprove the report that had been tabled by Wycliffe and Paul in regards to the check-in and checking out time. Further, the Court of Appeal indicated that the checking in and the checking out system was actually the property of H. Young, and therefore H. Young could not disprove the findings of the system that they actually owned. The court noted that the failure of H. Young to produce evidence to disprove the Staff Movement Summary Report, yet H. Young under Section 10 is the party that bears the obligation to keep records of the hours worked by the employees, was a major flaw, and therefore the Court of Appeal now found that Wycliffe and Paul had indeed established their claim for overtime pay and proceeded to uphold the decision of the Employment and Labor Relations Court, which had awarded them the sum of $942,000 as unpaid overtime. The Court of Appeal further proceeded to dismiss H. Young's appeal with costs. So what can we learn from this case? 1. The employee is the party that bears the legal burden and the evidentiary burden of proving overtime pay. As you have heard from the case of H. Young versus Wycliffe and Paul, Wycliffe and Paul produced two critical evidences to support their claim for overtime pay. They provided a computation sheet which indicated how they had arrived at the sum of $942,000 that they were claiming as a cumulative sum for overtime pay. They also provided the court with the Staff Movement Summary Report that indicated the checking in and the checking out time, further supporting their claim for overtime pay. This further supports our point on the fact that it is the employee who bears the legal and evidentiary burden at first to prove overtime pay. Thereafter, the employer should bear the burden of disproving allegations of overtime pay that are made by the employee. That means that the burden shifts to the employer after the employee has discharged their legal and evidentiary burden. As you can see from the case of H. Young versus Wycliffe and Paul, H. Young was unable to disprove the allegations, the evidence that had been produced by Wycliffe and Paul in regards to overtime, and that is how the court found that Wycliffe and Paul had actually established their claim for overtime pay. That marks the end of episode 8 of Employment Law Unlocked. But stick around for episode 9, where we talk about the other benefits under the Employment Act. You do not want to miss this. Thank you so much for watching, and see you on the next one. Remember, information is power, legal knowledge is freedom.